Florida statute 810.02. Burglary with a dwelling, in a dwelling with a firearm. Mr. Okafor didn't enter the home. The state hasn't even proved beyond a reasonable doubt that he entered the home. You can't convict him on that. There's reasonable doubt. The state's professional sworn witness that we trust said that the victims said that they had on masks. Reasonable doubt. Robbery with a firearm, 812.13. Again, I'm going through what Mr. Mallett set forth to you in his closing. State can't prove that Mr. Okafor took anything from Brown for what I've just got finished telling you. And ladies and gentlemen of the jury, I respect your service so much. But I have to zealously represent my client in this closing. So some things will be redundant. Again, can't prove it. Detective Mullen said they had masks. Aggravated assault with a firearm, 784.021. No fingerprints are on that firearm. He wasn't found with a firearm. Again, the shoe evidence. My goodness. And again, ladies and gentlemen of the jury, pardon me. I guess that fits. See, it's even confusing for me. You see this? Hopefully I got this right now. This. What is that? Doesn't match anything. It's confusing. And she told you it's not 100%. It's got to be 100%. If it's confusing and not 100%, and it's got all this bad stuff in the peanut butter and jelly sandwich, not guilty. Bessman Okafor, not guilty. Mr. Mallett also talked about the fingerprint on this blue car. The witnesses saw it allegedly saw it through the TV. It's supposed to be purple or something, but it's blue. Fingerprint on there should be there. It's Mr. Okafor's car, mom's car, or something like that. So he was over there waiting on, meaning he had been in it before. Waiting on Mr. Bernard to bring him this stuff. I will presume Mr. Okafor innocent unless Mr. Okafor is proven beyond, strike that, unless Mr. Okafor is proven guilty beyond and to the exclusion of reasonable doubt. During voir dire, that was stated to you. You took an oath. That's what you said you would do. Uphold that oath, because you can see that even sworn officers can't uphold the oath, and they don't. But because we are in this country, the United States of America, under this great Constitution, it gives you, the people, the jury, the power to correct wrongs, to correct inconsistencies on the unpopular, just like the popular accused who are presumptively innocent. It protects the powerful and the small, the popular and unpopular. Can you believe just think about the Constitution if it didn't protect the unpopular, or if it didn't protect the weak, or if it didn't protect the poor. That's not what this country is made of, and that's not what this process is made of. I purposefully went through those amendments to help you all understand the magnitude of your duty. It's important. It's just that you have the power. That's how the framers of this Constitution intended it. This is how it's supposed to work. You find him not guilty even if you don't like it. It's important to the Constitution, and it's important to send a message that a sworn police officer that protects us.
Judge, I'm going to object to the argument sending a message. Not an appropriate argument, Your Honor.
Sustain. Let's move on to something else, please.
Ladies and gentlemen of the jury, again, when the evidence introduced by the state contradicts itself and it's confusing and it's inconsistent, you must find the accused not guilty. It necessarily means that it's reasonable doubt. Let me also apologize if my passion about this matter has been offensive, but I have a duty, and I took an oath to zealously advocate for and represent my client. Let me also apologize to my colleague and the other officers of the court if that was offensive. But when this happens, it necessarily means that it's reasonable doubt. There's reasonable doubt as to the charges for Mr. Okafor. You must find him not guilty. As a result, again, thank you for your service.
Thank you, sir. Let me sit counsel at the bench for just a moment. Folks, what I'm going to do is ask you to step back inside 5 minutes, give you a short break here, and we'll try and figure out from a timing standpoint what's the best to do. okay if we go to about 12:30, quarter of 1 before we break for lunch?
Channel 2.
Bessman Okafor has ditched the eyeglasses and he's looking concerned.
Channel 2.
Bessman Okafor has ditched the eyeglasses and he's looking concerned today as he gets closer to finding out whether he'll go to prison for the rest of his life. The state told the jury this morning during its closing argument that the evidence is strong against both Okafor and his co-defendant Nolan Bernard through witness identification, the fact that both were caught with the victim's stolen property, and because Okafor ran when police caught up to him only about an hour after the 2012 home invasion.
This isn't simply wrong place at the wrong time. The two of them are on trial here together because they chose to commit this crime.
Okafor's attorney tried to convince the jury that the Ocoee police officer and the victims gave conflicting testimony and reminded them not to penalize Okafor for not taking the stand.
He does not have to say one word. The state has to prove everything. Mr. Okafor has to prove nothing.
We need a minute to get set up, Mr. Clark. All set. If our jury's ready, let's bring them in, please. Please be seated. Folks, we have ordered your lunch. We placed the order. It's going to